be included in all procurement and construction projects be awarded at least 10% of the dollar value of the entire procurement or project. And while the state eclipsed the 10% threshold in fiscal 18, reaching more than 14%, and again in the following year, 19 to 13%, the pandemic exposed obstacles and structural barriers facing our minority communities. And this was the case in state procurement as well. In fiscal 2020, MBE participation fell to about 8%, a disappointment. Before the pandemic, the state engaged a consultant to conduct a disparity study to determine if there is a statistical underutilization of MBEs based on their availability in the market. And while this study is intended to protect the MBE program from legal challenges, it also provides an opportunity for us to see what can be done to improve the program, make it more accessible for the MBE community, and increase the utilization rate. While 10% is the minimum threshold, our policies to promote the fullest extent possible participation of MBEs in state procurements. This work requires all stakeholders to have a voice, and that's why we're hosting this event. And your input today and going forward will be critical in improving the program and bolstering participation. Please note that the recommendations made by the consultant have not been approved by the administration. That work remains ongoing. And with that, I'm going to turn it over to Dorinda Keene, the Acting Associate Director of ODO, who will describe the report and its findings.
Thank you, Director. Derek, could you please bring up the presentation? And if you could advance to the next slide, please. Good afternoon, everyone. The impetus for the state conducting this study was the legal determination that certain mandates and requirements found in our current MBE statute and regulations were determined to be legally indefensible in the absence of a current valid disparity study. As a result, during the Raimondo administration, the state of Rhode Island issued a solicitation for a disparity study, and we contracted with Mason Tillman Associates, a nationally recognized firm, to provide the necessary statistical analysis to meet the legal and constitutional requirements to support our existing MBE program, as it is established under Rhode Island General Law 37-14.1. The study utilized data from our fiscal years 2015 through 2017, and the resulting 260-page report includes 21 specific race and gender conscious recommendations to support and improve the state's MBE program. It is now my distinct pleasure to introduce you to Dr. Eleanor Ramsey, Principal of Mason Tillman Associates, who will walk us through their methodology as well as their recommendations. Dr. Ramsey, the floor is yours.
Thank you very much, Dorinda. It is my pleasure to be here this morning to be able to discuss with you the objectives of the disparity study and to present to you the legal underpinnings for that, for the analysis that we performed and the recommendations that we offered the state as a result of what we learned in the study. So move forward to the next slide. The purpose of the study, based on the Croson decision, and Don O'Bannon, our legal counsel, will talk about that in a moment, but is to determine if available minority and women-owned businesses that reside within the state of Rhode Island were underutilized at a statistically significant level. And that involved analyzing the use of minorities and women and non-minority males in the award of both prime and subcontracts. The standard that guided the research that we performed for the state was set by the United States Supreme Court in the decision, City of Richmond versus J.A. Croson. And before talking about the methodology that we use, I'm going to ask Don to give you the legal underpinnings that guided the research that we performed. Don?
Thank you, Dr. Ramsey. Next slide, please. The City of Richmond decision was decided in 1989. It was the 14th Amendment challenge to the City of Richmond's MBE contracting program. The City of Richmond had a 30% goal, and in reviewing the evidence supporting the city's program, the Supreme Court determined that the program as implemented violated the 14th Amendment. The court, under Justice O'Connor, who wrote the majority opinion, said that there was no evidence of the available pool of prime or subcontractors in the marketplace. There was no direct evidence of intentional discrimination or that the city had become a passive participant in discrimination. And therefore, the court concluded that the program also was not narrowly tailored and should be not upheld as being constitutional. The significance of this Richmond v. Croson decision is not so much the facts, although they do provide guidance into what the court was looking at, but the fact that the court changed the standard of review. Prior to Croson, the standard of review for governmental entities was to use what is called a rational basis. If there was a rational basis for the use of race in the city's activities, then the court would review that and uphold that standard. But in Richmond, the court really changed the landscape and applied what is called strict scrutiny. Strict scrutiny has often been considered strict scrutiny fatal in fact. That's, inside commentary for lawyers. However, Justice O'Connor made it clear that the strict scrutiny legal review standard should not be considered fatal in fact. That governmental entities do have a compelling interest in addressing discrimination either by its governmental entity, government employees, or by those third parties that the governmental entity does business with. Now, the standard enunciated in City of Richmond v. Croson was a two-pronged standard. One is that the governmental entity to use race must have a compelling interest. And a compelling interest, must establish that it has a compelling interest. And a compelling interest is established by having what is called a strong basis in evidence. A strong basis in evidence is established by having a statistically significant disparity between utilization and availability. Let me say that one more time. That's always a mouthful. A statistically significant disparity between availability and utilization. On the issue of race, if there is a statistically significant disparity, then there is a rebuttable inference of discrimination, and the governmental entity may use race in its contracting process to address the discrimination. Next, the remedy must be narrowly tailored. And what do I mean by narrowly tailored? The narrowly tailored remedy or the alleged discrimination by the governmental entity. The remedy must address that discrimination. Let me give you an example to make it a little bit more concrete. If you have a situation in which African Americans were overutilized by the state of Rhode Island, and there is not a statistically significant disparity, but Hispanics were statistically significant, then the program must be narrowly tailored to address the discrimination that exists by that governmental entity against the Hispanic business community, as opposed to including within the program African Americans who no longer have a statistically significant disparity. So the remedy has to be narrowly tailored. When you have a narrowly tailored remedy, it's important to note that there are going to be, and the consultant must address, disparity findings by race, gender, and these disparity findings must be industry significant. It's important to note, and more as a footnote, that the City of Richmond case did not establish a standard for gender. You noticed earlier when I was talking about Richmond, I spoke of the MBE contracting program. So if you have an MWBE program, the women component of that program is subject to a lesser standard called intermediate scrutiny. So going back again to the narrowly tailored. So you have to remedy documented discrimination. Disparity findings are going to address each ethnic group. And then the subcontract goals are limited to the ethnic and gender groups in each industry with disparity findings. If there is a parity or an overutilization in architects and engineering, but there is a statistically significant disparity in construction, you can narrowly tailor a program to address the discrimination in construction. It would not, however, include architects and engineers in the absence of disparity. The goals, and Mason Tillman's methodology will be explained later, are going to be defined by the availability of the ethnic and gender groups with disparity in each industry. One of the things that was laid out in Croson, that you are looking at the available pool of businesses that are ready and willing in your marketplace. City of Richmond had used a standard of arguing that the population of Richmond, Black population, was of such a significant level, and wanted to set its goal in part based upon the level of population. The court simply rejected population as having any basis in order to make this in applying this strict scrutiny standard. It's also important to note that the study collected what is called anecdotal evidence. And some of you might have attended some of the community sessions that occurred pre-COVID. And the anecdotal evidence that's collected is basically the perspective of individuals who have attempted to do business or have done business with the state of Rhode Island. And in the words of Justice O'Connor, one of my favorite quotes is that the anecdotal evidence brings this to life. They provide some framework in order to, or guidance, hints, however you want to characterize it, as to what is going on and why the statistical evidence is where it is. Are there disparities to participation that would limit participation? All of those types of issues seem to be addressed or come out in the context of the anecdotal evidence and the collection of that anecdotal evidence. Once this framework was established, strict scrutiny, compelling interest as one prong, narrowly tailored as the second prong, in a subsequent decision called Adoran versus Pena, the Supreme Court also applied that same standard of review to actions by the federal government in which race is used in their contracting process, and said the federal government had to have a strong basis in evidence in order to utilize race conscious measures in terms of next slide. And with that, I turn it back over to Dr. Ramsey for a discussion of these study plans.
Thanks, Don. And so Don has provided the framework that guided the research that we did in our effort to compute and to compile data and to perform a statistical analysis. And so the three parts of that analysis are the utilization, availability, and anecdotal. Utilization, we studied both formal contracts and informal contracts, distinguished by those contracts that required the advertising versus those contracts that could be awarded without advertising. So we studied both those. We also attempted to study all subcontracts. We were successful in being able to reconstruct sufficient subcontracts for construction, but professional service contracts, it just was not possible with the process data that was available to reconstruct those. On the availability side, we were charged with identifying businesses in the state that were willing and able to perform the state's contracts. And then, as Don indicated, to collect anecdotal accounts in order to understand how businesses perceived those experiences. On the study period, we did an analysis of the period July 1 through 2014 to June 30th, 2017. So we were commissioned to perform this study several years before the pandemic. So we had a view of what existed prior to it. And the ethnic groups were Black Americans, American Indians, Alaskan Natives, Portuguese Americans, Hispanic Americans, Asian Americans, Caucasian females, and also non-minority males. So the full spectrum of businesses were included in that analysis. We also studied the industries that included all of the contract types that were awarded by the state. And so we did construction and construction-related services, as well as a class called services, which included professional services, as well as other non-technical services. And then on goods, commodities, and supplies. And so that constituted the scope of the study. The next slide, please. The utilization analysis, we identified through the relationship with the state, able to extract the prime contract data that was awarded and payment data for those contracts that were awarded during the study period. And then we had to clean that data to ensure that we had only one record per contract and that the data had a payment and an award amount. And so we did what we call normalizing the data. Once that was done, we had to assign to each contract an industry, since our analysis was going to be limited to a discussion and a calculation of use by industry. And for each of the prime contractors that we secured from the data, we had to ensure that the ethnicity and gender was appropriately assigned. And that involved several steps of research to ensure that that was complete and accurate. As I noted with the subcontracts, we were able to get some from the state. Some of those subcontracts had to be reconstructed, and that involved surveying the business community to secure from them information about the subcontracts awarded on their prime contracts. And that led to sufficient data to analyze the construction subcontracts, but not sufficient to do professional services. So professional services data will need to be collected over the coming year. And subsequently, the state might want to look to see what the subcontracting use was on those. But we have recommended that tracking and monitoring of all subcontracts be part of the next phase of the program enhancement. And therefore, there should be sufficient data subsequently to analyze the actual use of minorities and women on professional service contracts. And then our geographic area is where we sought to identify the available businesses. So let's move to the next slide, please. So we needed to determine, based on the standard that Croson enumerated in that decision on the 23rd of January, 1989, the contractors that were in the market area who were willing and able to perform the state's contracts. And one class of business would be those businesses that were willing and able to perform other on both the state's contracts and other government contracts. And that would be businesses that were certified by any number of agencies as either veterans-owned, small business, minority women. But we looked at the full context of trying to find businesses within the state that had performed government work. For those who clearly would be willing to do business with the state of Rhode Island. In addition to those businesses we identified that were associated with or had performed a government contract, we sought beyond that to identify other businesses that had not done government work or had not been certified in order to have the broadest definition of available businesses. And so for those that we found from various association listings and other source of data that we were able to compile, we had to ensure that they were actually willing to contract with the state. And for all of the businesses identified as willing to do business, we had to establish and verify their race, gender, and then classify those vendors by the industry in which they operated. And we also did an assessment of capacity. One of the decisions subsequent to Croson has emphasized the importance of what Croson called as ABLE. And so we did do an analysis of the bidding history, revenue, number of employees, owner education to determine the profile of the minority-owned businesses and similarly situated non-minority male businesses. So that constituted the work that we did to compile the available businesses listing and to in turn classify those identified businesses by ethnicity, gender, and industry. Next slide, please. So as Don has indicated, the obligation under the Croson decision is to determine if the minority and businesses, and in this study, as it's been all of our studies since Croson, we've looked at both minorities and women, albeit Croson was addressing the conditions that existed in the city of Richmond, which was a minority business program and not a minority and women-owned business program. But we've looked at both minorities and women. And based on the test that is set forth in Croson, we had to determine what the disparity ratio was. And that is to analyze the actual dollars spent and divided by the expected dollars. What is to be the condition that should exist? There should be parity. There should be the use should be equal to the availability. But that is determined by the disparity ratio. In instances where when the disparity ratio is calculated, there is parity or overutilization or insubstantial underutilization, which means that there is the ethnic group is underutilized, but it is underutilized at a very low level and therefore not subject to considered statistically significant. So under those circumstances, you can have no minority or women business goals. And again, since the goals are ethnic and gender specific, it would mean that any group that was at parity or overutilized would not be included in recommendations where race was a consideration or gender. So with women, since they were not subject to the review by Croson, their standard is a lesser standard than that for minorities. And so if we need only a substantial underutilization in order to set WBE goals. And so that would be discerned when looking at and examining the disparity ratio. For minority businesses, substantial underutilization, then is a statistical test is applied. If that test determines that that underutilization is statistically significant, then MWB goals at subcontracting level with a finding of statistical significance for subcontractors for any of the ethnic groups there could be, in fact, goals could be applied to subcontracting. And where there was no statistical significance, there could be no minority business goals applied to that ethnic group, ethnic group, or within a specific industry. And so that's our standard for the statistical test. The next slide, please. The anecdotal information that's compiled through a survey of the willing businesses who were queried for their experiences in the market area. We use that information to help in formulating recommendations that were race and gender neutral. And it's very informative and very useful for that source of information in this work. However, you cannot use it to make a finding of discrimination, but you can use it to formulate recommendations. And so it has informed the race and gender neutral recommendations, which comprise a significant portion of the report that we prepared. To the next slide, please. So those recommendations fall in a number of categories. To the next slide. Those recommendations include race-specific as well as race-neutral recommendations. And at the prime level, where you cannot have goals, there are the opportunity to have bid discounts to offset the adverse impact of discrimination for those groups for which there was a determination that there was a statistically significant underutilization, that the use of a bid discount is one way to offset the conditions that were reflected in the statistical significant finding. And so we have recommended that on construction contracts, which are awarded based on low bid, that a 5% bid discount be applied, which would take the particular bid that might be $100,000, and 5% of that, if that bid were submitted by any one of these 5 groups that had a statistically significant finding, that would be reduced by 5%. So that bid at 100,000 would, for comparative purposes, would be 95,000. And if a group, a prime contractor that was not one of these 5 groups submitted a bid at 96,000, they would not be the lowest bidder, even though the groups affected by this discrimination had a bid at 100. It would, for evaluation purposes, be 95,000, and the 96 would no longer be the lowest bidder. But for purposes of the actual contract awarded, that prime contractor would have received a contract valued at 100,000. There's a ceiling set on the number of dollars that could be included in that bid discount, and that would not exceed $50,000. And a similar recommendation for goods and services, again, reducing the price for competitive purposes, for evaluation purposes, by 5%. And in this instance, the finding was that Black Americans, Portuguese Americans, and Caucasian females each had a statistically significant disparity in the award of goods and services contracts at the prime level. So to the next slide, please. On the award of contracts where the decisions are made based on a proposal or a statement of qualifications, there is a recommendation that in those evaluation points that are available, that 10% of those evaluation points should be for construction-related services, should be awarded based on ethnicity and gender for the 2 groups that had a disparity. So that, again, 100 points that would be available, 10% of those points would be for status of prime contractor that was either a Black American or Caucasian female, and they would get 10 points. And the available points that for any other group that did not fall within that those 2 categories, the max that they could receive would be 90%. And so that's recommended for construction-related services, as well as professional services, again, where the decision is based on a proposal or a statement of qualifications. And each of the groups that would be eligible for those evaluation points would be those groups that had a statistically significant disparity in their use in the years that we studied. So to the next slide, please. So on the subcontracting goals, subcontracting is the area of procurement where you can set a goal, because in that instance, each prime contractor would be required to use subcontractors, and that the maximum level that would be stipulated in a prime contractor's solicitation would be the availability level for each of those groups that had a disparity. And so that we recommend that those goals be applied for construction projects, because it was only in construction that we were able to compile sufficient data to assess the presence of disparity. And so there, the goals would apply those at that level. We are recommending, however, that the goal level of participation that is achieved by the prime be stated in the bid and be made available for review at the time that the bid is submitted. There's also a provision for good faith effort, which would be a determination by the prime and documentation by the prime that it was not possible to meet the goal. That would have to be reviewed at the time of bid opening as well. What is also important is that we are recommending that any company that is listed to meet the goal perform a commercially useful function, and that too would have to be determined at the time of bid opening. So it brings integrity to the program that the subs are listed at the time in the bid for construction. It's established that those subcontractors are certified to perform the service listed, and that they are indeed to perform a commercially useful function. To make this program effective, because it does take oversight and it takes skill and knowledge, we are suggesting that the ODEO program be augmented with staff that can bring that level of competence to enhance the existing staff, and also that there's an ombudsperson to work on behalf of the minority and women business community to ensure that issues, complaints, disputes are responded to in a direct and effective and functional manner. Next slide, please. So we also are recommending that each department have a designated MBE, WBE liaison officer, who again will ensure that within the confines of the department, that the provisions of the program will be carried out effectively. Staff will ensure that the businesses that are determined at bid opening to perform a commercially useful function actually carry out that function, and that they are actually used during the course of the contract consistent with the plan that is established. And so that function at the local level, departmental level, is very important. We're also suggesting revamping the master price agreement procurement method. Significant number of contracts are awarded under this process procurement method that allows for the selection of a vendor, and that vendor will then be assigned projects over the life of their contract. And what the analysis showed was that many of the projects that are assigned to a contractor that has a master agreement are small projects, although the requirements to compete for a master price agreement contract are higher than the actual capacity needed to perform the individual projects. And so we think that this program needs to be revamped and to align with the capacity requirements for those purchase orders that are issued under the master agreement, and that also fewer contracts are placed under control of a limited number of vendors who receive the master price agreements. So we believe that this particular procurement method needs to be further examined and to assess and appreciate its adverse impact on minority and women-owned businesses. To the next slide, please. And also that the master price agreements also have goal subcontracting requirements to ensure the participation of minority and women business on those contracts as well. And we also recommending a sheltered market program that will limit competition for contracts under 100,000 to minorities and women and other small businesses, so that those contracts would not be under the sheltered market would not be awarded to larger contracts. We think that will help in building the capacity of businesses. Also, it's an excellent program for bringing more minorities and women into the competitive process and having access to state contracts, which would then lead to relationships that could foster the award of even larger contracts. And substitution provisions which exist in the procurement process need to be adhered to, and companies that are listed to meet the goals and to participate on a project cannot be removed without a formal hearing and justification based on written standards, which would prevail and be provided in all prime contracts where there is an MWBE goal. To the next slide, please. So subcontractor data, which is not systematically captured presently, should be captured for all contracts. And that would ensure that there's sufficient information to determine who is participating and whether the companies participating as subcontractors are actually those that were listed in the bid and approved at the time that the contract was awarded. And it will provide adequate and reliable information for purposes of determining the level of use both on construction contracts and on professional service contracts. So we think that that process is very important for a verifiable and reliable and comprehensive program. And then there should be publication of the utilization, which would be reviewed on a quarterly basis and publicly made available so that all the community will know what success the state has had in its implementation of an enhanced program. And prompt payment provisions would be used to ensure that the prime contractor is paid timely and that the prime contractor pays its subcontractors timely. And that's all subcontractors and all prime contractors. So with the existing legislation to be enforced to ensure that there is in fact timely payment in accordance with the rules, and that the prime contractor will know when the state has issued its check, and that the subcontractor in turn will know when the prime's check has been issued, so that there can be monitoring and control over that process. So to the next slide. We also think that based on the information that we discerned in our review, that a formal dispute resolution process, which would be supported to fund and the ombudsman position, is important to ensure that issues that arise related to payment, related to scope of work, mobilization, other factors that have an adverse impact on the success of a business in performing state contracts would be addressed, and there would be a set of routine procedures that would be followed to ensure that the issues are addressed and that they are addressed timely. And sanctions for failure to be in compliance is something that has been effective nationally and ensuring that a program proceeds as it is defined in the law. And then the handbook that will formalize these recommendations that are adopted by the state and be made available to the public who can have access to it, as well as all internal parties will know exactly what is expected, and in turn make a program much more effective and broad in its reach. The next slide, please. So part of having an effective manual is to ensure that all staff familiar with the contents of the manual and know what their accountability is for aspects of the program. And so we are recommending that the state institute and develop a training module that would be used across the departments, colleges, and universities. And it would be part of all new employee training, and that periodically there would be refresher courses to ensure that there is an understanding of the rules as set forth in the program and the execution of those. And finally, we think that it is important that you have an outreach program that informs businesses of new standards, enhancements to existing standards, and the practices that will govern the office and the MWBE program. And that is important for businesses to know that there are going to be provisions that are intended to ensure equity in contracting, and a good and comprehensive outreach program should ensure that. So to the next slide, please. I want to, at this point, turn the program back to Dorinda to give you the state's next steps. And thank you for the time that you have devoted this morning to this gathering, because we feel that the report that was produced is important, and we're pleased that the state has moved forward to bring this to you as members of the business community. Thank you.
Thank you, Dr. Ramsey, and thank you, Attorney O'Bannon. With respect to the next steps, in the short term, we will be doing the following. Number one, we will be developing a robust training program for agencies that will include information on how to manage contracts, monitor and report on MBEWB contract compliance for the same, for their agency-specific contracts. Number two, we will be implementing a modern ERP system across state agencies to enhance our ability to properly collect and monitor data and compliance, including the ability to capture subcontractor data and payment information. Number three, we will be increasing staffing within the Office of Diversity, Equity, and Opportunity and reimagining the way ODEO operates. And four, we will be enforcing areas within our existing state rules and regulations that are already more robust than the consultant's recommendations. In addition, in the longer term, we're going to be continuing to review the study in collaboration with the General Assembly and the Governor's Office, and we will pursue regulatory and legislative changes as necessary. I thank you very much for your time this afternoon. The full study, as well as the executive summary, are currently posted on the ODEO website, and Derek has included the link to those documents in the chat today. Thank you very much. I'm going to turn it back to Director Thorson for his closing comments.
Thank you, Dorinda. And thank you, Dr. Ramsey. I just want to say that this is a priority commitment of this administration. We will be moving forward to do our best to satisfy the requirements of state policy, and we will begin that implementation very soon. We're talking about days and weeks, not months, to get this up and running. So that is something that has generated quite a bit of interest from our minority business enterprise community, and we want to assure you that we are moving back from a situation where we fell short. And some of that had to do with the pandemic. A lot of it did, in fact. But with this study, we will be moving forward with greater confidence in being able to meet our utilization threshold obligations. So with that, I just wanted to thank everybody for attending today. Derek is available if you'd like to send him comments or questions. And with that, I'd like to thank you once again and say goodbye. Have a wonderful afternoon.
Thank you.